Karua, EGH. We have Joyce Majiwa, SC. We have Jeptum Bulut. We have the Vice President of the Law Society of Kenya. We have Masija Limo. We have Sylvester Mbidi. And online we have Daisy Amdani. The moderators are Faith Odhiambo and Valentine Kaminwa. Let's start off.
Good morning, everyone, and thank you for joining us. My name is Faith Odhiambo, an advocate of the High Court, and I'm one of the moderators.
Good morning, everyone. I'm Valentine Kaminwa. Thank you for tuning in today. I'll also be moderating today's discussion.
So it is my honor to introduce our panelists. We have Honorable Martha Karua, EGH. She's an accomplished lawyer, a well-respected politician with over 3 decades of experience behind her. She's renowned for her uncompromising integrity, her passion for gender and social justice, inclusive governance, conflict resolution, and development issues. She's well known across Africa, and especially in East Africa, in her fight for inclusion of women and also in reforms in the Constitution. As a Minister of Justice and Constitutional Affairs, she was the lead negotiator for the government during the 2008 post-election crisis. The negotiations led to the signing of the National Accord and formation of a grand coalition government by the protagonists. She was involved in the constitutional making process. She resigned on principle in April 2009. Martha is the party leader of the National Rainbow Coalition Party, NAC Kenya, on whose ticket she ran for president in 2013. She remains active on Kenyan national political landscape and is relevant to date. Our other panelists include Joyce Majiwa, Senior Counsel, OGW. She's an advocate of the High Court of Kenya with over 25 years experience in legal practice and active participation in civil society. Madam Joyce Majiwa has provided leadership as the National Vice Chairperson and founder member of FIDA Kenya and also the chairperson of FIDA Kenya. She's also a member of the League of Kenya Women Voters. In these two organizations, Joyce has influenced greater recognition and protection of women's rights, both on social levels and at the political sphere. Joyce was a delegate to the convener of the Transitional and Consequential Arrangements Committee at the National Constitutional Conference, which led to the Constitution of Kenya in the year 2010, which ushered in great protection of human rights, social justice, and made progressive provisions on the citizenship of women, including the provisions of equitable representation of women and participation in public life. She continues to use her expertise and experience to advance social justice, human rights, and particularly women's rights, democracy, and development as a referral lawyer and legal advisor and consultant in human rights. Currently, she's the lead counsel representing FIDA Kenya in the legal suit for realization of the 2/3 gender principle in Parliament. She has a law degree from University of Nairobi, postgraduate diploma in gender and development studies from University of Nairobi, and masters in human rights from University of Pretoria. Also, we have Ms. Jeptum Bulut. Jeptum is an advocate of the High Court of Kenya and a partner at Usaidi Mwaura Ngarwa and Company Advocates, specializing in financial services and technology. She is a spirited advocate for gender rights, equality, and inclusion as part of We Are 5% Collective.
We're also honored to have Caroline Kamende on the panel. She is the Vice President of the Law Society and previously served as a council member in 2018. She's also chairperson of the African Bar Association of the Kenyan chapter, and she also served as vice chair of the association before. She's the managing owner of Kamende and Company Advocates, and she has experience in family law, arbitration, civil and commercial law, as well as international law. She has also practiced before the International Criminal Tribunal for Rwanda as a legal assistant. We're also honored to be hosting Ms. Daisy Amdani. She's tuning in remotely. Ms. Amdani is the Executive Director of Crown Trust. She is a governance and women's rights enthusiast. She's a practitioner with several years of experience working in the field of women's rights. She's also the coordinator of the National Women's Steering Committee, which is a platform that brings together individuals and organizations drawn from around the country on a county and a national level to harness a collective voice in their work towards political and economic emancipation of women. We're also honored to have on our panel Mr. Sylvester Nditi. He's a lawyer by profession and advocate of the High Court of Kenya. He's a certified professional mediator. He has experience working for the International Criminal Investigations Institute at The Hague in the Netherlands. He works as a senior legal officer at the National Gender and Equality Commission. He's the first legal officer to be employed by the Commission when it was constituted in 2012. And he has a wealth of experience in investigation of complaints related to the violation of rights and freedoms around equality and discrimination issues. Last but certainly not least on the panel, we have Ms. Mercy Jalimo. She's also an advocate of the High Court of Kenya, and she primarily specializes in gender equality and non-discrimination. She's a change agent and a Sheridan scholar. She is also a leadership and governance officer at the Center for Rights, Education and Awareness, which is called CREW.
Thank you very much. So, as we start off, Honorable Martha Karua, you're a force to reckon with. Maybe you could start off the debate by telling us the historical fight of women in the legal fraternity for constitutional reforms, and in your opinion, has Parliament failed us?
I think I begin by, when you talk about women, I think of FIDA, International Federation of Women Lawyers, because since I entered Parliament, and having been a council member and an active member of FIDA, we throughout were supported by FIDA. When I entered Parliament, we were 4 women in a Parliament of 188. And all the work we did around women's rights and pushing for women's gain, we would get support from organizations outside Parliament, the lead organization being FIDA. And we were able to do several things. I remember in 1997, when we had the IPPG, Inter Partes Parliamentary Group reforms, we were able to get discrimination on basis of gender outlawed. That was Article 80 of the then Constitution. We were also able to get Article 33A come in, which provided for equal share of the nominated slots between men and women, gender parity, if you like. And that was a milestone. That was the first time that the clause enabled nomination of women in every corner of the country, because the clause applied not just to Parliament, but also to local authorities. This was the beginning of a sort of quota system that enabled the face of women to be represented in the political space. FIDA was not only fighting for political rights, its rights across the board, but with regard to political participation, this was a momentous occasion. Thereafter, in 1988, that now was my second time in Parliament, women lawyers through FIDA and through working with women in Parliament was part and parcel of making a legal framework for the formal process of constitutional review to begin. And I remember that we had a drafting committee of 15, which is referred to as the Sulumeti Committee. And in that committee of 15, there were 5 women. We started the principle that wherever we have an organ of review, there must be at least 1/3 women. And in that committee was the then chair of FIDA, Martha Koome. I was there as a parliamentarian. Professor Wanjiko Kabera was there. I believe Phoebe Asia was there. And Abida Ali was there, who is now a judge. So if you look at the constitutional journey, from the time we formalized the journey in 1998, and even before then, women lawyers have been part and parcel, but women lawyers have not worked alone. I would not like the crown to go to women lawyers alone. Women lawyers were holding hands with the women of Kenya. And I remember around that time in 1997 there, we formed the Kenya Women Political Caucus, which was an umbrella organization, not registered, but an umbrella organization for all lead women organizations. It included Maendeleo, it included FIDA, the League of Kenya Women Voters, which I then chaired, and it has already been mentioned in Senior Counsel Majiwa's introduction. So many women's organizations, and we were caucusing together, and then those of us in parliament would act in accordance with the needs of women. Those of us in the drafting committee were not using our own limited wisdom. We were using the collective wisdom of women, and we used to caucus widely. And I would say then the journey today requires women in parliament to work broadly with women outside parliament and with organizations and allies, both male and female, who believe in gender equality. I think there is something else you had asked, which has...
I'd asked you whether you think, in your opinion, has Parliament failed?
Totally. Parliament has failed. They swore their oath of office is to uphold and defend the Constitution. They have only upheld the part that creates them as a parliament, but completely refused to honor the provisions regarding inclusion, because gender equality in political processes is about inclusion of both genders in political processes. So refusing to honor the 2/3 gender rule in relation to parliament is acting unconstitutionally. It is gross dereliction of duty, and it is time to dissolve parliament. And it is not the work of only the women in parliament. This is the work of parliament as an institution, a majority of whom are men. But parliament has failed collectively.
Thank you. Thank you, Senior Counsel. Indeed, the journey has been long. Ms. Kamende, please can you give us the views of the Law Society of Kenya regarding what's commonly known as the 2/3 gender rule?
Thank you, Valentine. Kenya is a constitutional democracy governed by the rule of law. And as the Law Society of Kenya, we are mandated under Section 4 to uphold the rule of law and constitutionalism. Towards this end, the Law Society has initiated the process of compliance with the Constitution. To answer the question, then I will give a snapshot of the decisions of the court that the Law Society looks forward to implementing. The first, I think the President had given a highlight of that. The first was the advisory, number 2 of 2012, where the majority of the Supreme Court judges held that the implementation of the 2/3 gender rule would be progressive, not immediate, despite the Chief Justice then, Dr. William Tuga, having found that the call for implementation of the 2/3 gender rule was to be done there and then. I think this morning we elaborated on that point. and is reasoning for that decision. There has been various court decisions. I think this is one of the principles of the Constitution that has been exhausted by litigation. There has been court orders that Parliament is yet to comply with. The first one was by Justice Mumbi Ngugi in 2015 in the Katiba matter, where she directed and ordered then AG, together with the Commission on Implementation of the Constitution, to make sure that to table bills in Parliament to ensure that Article 227, 8 and 81B is complied with. Nothing happened. Another decision was by Justice Mativo in the crew matter, and he directed that that Parliament do table legislation to ensure that there is compliance of that principle. And failure to that, he directed that he ordered, not really actually directed, that any person could petition Parliament to petition the CJ, who would then write and advise the President of the Republic of Kenya to dissolve Parliament. That was to be done. It has not been done. The advisory number 2 of 2012 had also given a time framework 5 years from then that ended on 27th of August 2015, within which the legal framework to comply with that constitutional imperative was to be done. And despite an extension by 1 year, Parliament has still not done that, even to date. The Speaker of the National Assembly appealed against the decision of Justice Mativo, and the Court of Appeal made an interesting observation that there is no good faith on the part of the Parliament to enact legislation to comply with this principle, and that marks the end of the story in terms of legislation. Of course, in between there was a case by one Marilyn Mudhoni on the composition of the cabinet, and the late Justice Onguto found that the composition of other public organs and bodies should also comply with this truth has gender role, and but he deferred the decision to the coming elections. What am I saying? I am saying that we have exhausted the legal battle in courts, and the Constitution gives a last resort, that is Article 261(7), that any person can and should petition the CJ, who would in turn write and advise the President of the Republic to dissolve Parliament. There was an attempt in April 2019 by a lady called Margaret Toily to petition the CJ to advise the President to dissolve Parliament. But the CJ, in his letter of 27th of July 2019, observed that there was a pending special interest bill in Parliament, and his ruling or direction was that there was need to wait for that framework to be finalized, which has never come to fruition. On the 17th of July 2020, the Law Society petitioned the CJ to comply with Article 27, 8 and 81B of the Constitution that directs that there should be no more than 2/3 members of the same gender in both houses. And we, as the Law Society, are pursuing that. On the 30th of July 2020, the CJ directed that the speakers of both houses, that is the Senate and the Parliament, to respond to our petition within 14 days. The reason we are having this discourse today is because today is the 14th day within which the Speaker of the National Assembly and that of the Senate ought to have responded to the petition. At
Article 261 7 is couched in mandatory terms. It does not give any discretion to the CJ. It does not give any discretion to the President of the Republic of Kenya once there is a petition tabled by any party. And I think the first decision having come on the dissolution of Parliament, having been done in 2017, it appears then there is no goodwill on the part of the Parliament to comply with this constitutional imperative, which is not a women issue. It is a constitutional imperative founded on the tenets of democracy and also the rights of representation of the majority. So as the Law Society, whose duty is to advise the public on the law and also the government, and also ensuring that we uphold the rules of law, the rule of law, we shall pursue that petition to its logical conclusion. The 2/3 gender rule, it's not only on the representation in Parliament. Article, I think, 172 also puts a role and obligation on the political parties, on the JSC, and also political parties under Article 91 to ensure that there is compliance of that principle in the Constitution. So it is time also as a Law Society that we did data to find out what other bodies are unlawfully constituted, starting with our own. Do we have decisions emanating from public bodies that do not comply with that 2/3 gender rule? So that would be the battle that the Law Society is ready and willing to tackle in regards to this constitutional provision. Thank you, Valentine.
Honorable Martha Karua has given us an overview of the fight for women for constitutional reforms. And so, Senior Counsel Joyce Majiwa, from what we have heard, FIDA Kenya played an integral role in this journey. Maybe you tell us some of the milestones for FIDA Kenya in the fight for constitutional reform, and what has FIDA done particularly towards realization of this 2/3 gender role?
Thank you very much, and thank you, LSK, for making this very timely meeting. And thank you for embracing. Tell the world that gender issues are not about women only, but it's about everybody. So I really am happy with the LSK for taking this part on board. With regard to milestones for FIDA Kenya, I think they are many. Women's rights and FIDA Kenya are almost synonymous in this country. And there are many things to say. If I can highlight it, the way we highlight in the course, is to say that FIDA Kenya introduced a rights-based approach to the issues of women. That is the fundamental thing. Initially, there was, oh, go and ask them so that they can give you a piece of land, or go and ask them so that they can have sewing materials, or go and ask them so that we can have knitting materials. FIDA Kenya brought in the fundamental, along with others, of course, issue of women are human beings. We are citizens of this country, and therefore we are entitled to what citizens of this country are entitled to. So that rights-based approach was, to me, the most important thing that FIDA Kenya introduced. Following this rights-based approach, then FIDA Kenya looked at what is causing women to be how they are, what is causing this disparity. And it was not even difficult to know, because you could see, as practicing lawyers, you could see that there is distinction in the law, women and men. There is distinction and there is exclusion in the law, and in practice, women and men. There is all these things. This is why I think the base came out like FIDA is against men, but it is because they looked at the distinction, they looked at the exclusion, they looked at the restrictions which were coming. And invariably, the women who were practicing, and I think Senior Counsel Honorable Mata has really elucidated the earlier times, people who were coming to our practices were coming with, I was working for this organization and I'm not allowed pension. I'm being sent away empty-handed after working together for 20 years with my husband. Practical things that were coming to us, and we realized that this is systemic. It's not just about this woman who has come, she's being sent away by the bare cloth on her back, but it is a systemic. It is something that we need to tackle at policy level, we need to tackle it at legislative level. So that approach, to me, it was the most important thing, because it then led to the change of the law. Honorable Karua has already said that the change of the law, which at the highest, at the apex, was saying you could discriminate on sex on certain matters of devolution. And devolution is how we all devolve property. You know, most of our parents got property because it devolved to them, which means that if it was devolving to women, then women didn't have property. Okay, so devolution was just that was just one of them. So fundamentally, we needed to change the law. We needed to change the policies, and we needed to change the practices. What has been very, very difficult to change are the attitudes, which we can now see even spilling into the two-third gender issue. It is an attitude issue. It's not that we don't have a framework for it. Is it that Kenyans cannot implement a simple constitutional provision which says in elective and appointive positions, no more than 2/3 should be of the same gender? Of course, Kenyans are capable of really articulating this in the law and in their policies and in practice, but it is that attitude which they don't want to. So that rights-based approach was very important. FIDA itself is symbolic of where women can go if they need help, which other organizations or other places will not give. So, I mean, even though it has become a cliche of, I'll take you to FIDA, but it means that I no longer not have anywhere to go, which is what was the position when we started practicing. Women didn't have anywhere to go, and very little money to engage a lawyer. So that is a place, a very important contribution, thematically, a place to go. From that has sprung a lot of other organizations where women can go politically, where children can go, where other people can go, but giving birth to rights-based organizations, for me, that's another very, very important thing. And then conscientizing the society. I think FIDA did conscientize the society to the rights of women. These days, even at my local primary school, if we convene a committee meeting and there is no what they call gender, they will not start. But when 2-3 women will walk in and they say, oh yeah, gender has come, now we can start the meeting. That conscientization, to me, is something very important. So without saying which are the cases which we did, which were very, very many, I will say that that conscientization, and it is still there with us, the most important contribution with regard to that is anchoring it in the Constitution. Article 27, which we all know of the Constitution. I think that sprung from the people that fought for it most was the women's organizations. Let us put it in the Constitution that there is a right to equality, that the state must take steps to remedy the wrongs which the Constitution so readily recognizes. So entering this status of women in the Constitution, again, that was something thematically which FIDA did. Without taking more time, with regard to now two-third gender case, representation is very important. Honorable Martha has said Parliament is where decisions are made. Decisions that affect every aspect or every facet of our lives. Now, if one gender is missing from there, then there is something very, very terrible that is happening. So that is representation must come. Initially, we were when the Constitution was promulgated, we were very innocent and naive, and we thought everybody has the same sense of we want to make everybody equal, we want to make every Kenyan count. But apparently that was not the case. And after 5 years, which was the time allowed for Parliament to make law, and they didn't make law after Crew Crown case, which has been stated, and I think the President really gave the chronology. When 2017 came and this circle was going on, FIDA said that we must now file a case, not to then depend on the CJ, because the CJ may go to the President and advise him to dissolve the Parliament. But what if he does not dissolve the Parliament? We said that there is a mechanism in which the Parliament can be dissolved through the court processes. How? Because it is not properly constituted. It is constituted outside the Constitution. If a constitutional or arm of a government or any part of the government is constituted outside of the Constitution, of what the Constitution say, contrary to what the Constitution say, then the court can order its dissolution. And this case is still in court pending hearing in October.
Thank you very much, Senior. I'd now like to call on Ms. Daisy Amdani, if she could kindly share her experience of the journey as regards the NGO perspective. How far have you got to go?
Good morning, or rather good afternoon, and thank you, Valentine. Let me start by, first of all, thanking the Law Society of Kenya for this powerful conference and for taking the initiative to run with the two-thirds gender principle. I think part of my experience, particularly within civil society, is just how the women's voices are ignored and really don't count. When you think that from the experiences that we've heard from the other panelists, how women have been in the forefront fighting for their rights and a demand for the recognition of their equal right to participate. Everything that has been won by women, including the constitutional framework, is there not because the state felt that there needs to be some kind of change to the architectural, to the structure of our constitutional architecture that is more inclusive, but that the people, including and more so women, fought to have that inclusion enshrined therein. But when now we look at the process of animating the Constitution, women have been in the forefront running with it because the state continues in all its levels, particularly at the executive and the legislative level, continues to ignore the voices of women. When you think that the court orders, today the country is lamenting the lack of obedience or adherence to court orders. The state disobeys them willy-nilly, and everybody is complaining. But when you think that the first court order that was ever disregarded by the state was that with regards to the two-thirds gender principle, and that brings us to really the status of women. And I think that this, for me, is one of the stark points that has really come out in the journey of the implementation of the two-thirds gender principle. And that is the place of women and the status of women in Kenya. That the state continues to adopt a very biased approach to integrating women into the mainstream. If you look at the history of this country, the contributions of women have all but been erased from the founding of the nation to the constitution review process to the constitutional process. And so the attitudes continue to manifest in the manner that the two-thirds gender principle has been taken. Why do women want so much? What do women want? We've given them enough. Why do they want to be there? And so it's almost seen that women are coming to reap where they did not sow, but nothing could be further from the truth. And that, for me, is one of the most difficult things that we have to contend with as women. It's unfortunate that even in the face of the law, the state and the parliament Parliament itself remains stubborn, to include women, making women continue to have to justify why they need to be integrated into the mainstream. That question is constantly arising. Why do women have to, what do women want? Why aren't they satisfied with what they have? So moving forward, and I think that many of the speakers have talked about, and particularly Patricia Botte, where she has talked about, you cannot marginalize half of your population and expect the country to develop in a progressive way. The most important thing that people need to remember is that one of the key pillars of the Constitution is the two-thirds gender principle. Because the more and more a government actually represents the composition of its society, and when you think that women are over half of the population, then they are likely to be more stable policies, they are likely to be more inclusive policies, and we've seen that even with the women there. So it has been almost, sometimes we look back and we were having a discussion about that it's been 10 years. And that is not a short time. When you think that at the promulgation of the Constitution, those who may have been 17 years at the time who were not able to vote for the promulgation, for the Constitution, are today 26-year-olds. And we're still having to justify why the two-thirds gender principle needs to be implemented. For me, I think it remains a sad a series of events that Kenya, which is a leading economy in the region, and one that has enjoyed the benefits of continuity, because unlike our neighbors, we have not been embroiled in conflicts. So we've had the benefit of continuity and a fairly robust constitutional order, that for us, we remain the only country in East Africa and the IGAD region that has not even begun to implement the bare minimum. Because we must remember that the two-thirds gender principle, the minimum one-third, is not the pinnacle. In fact, we treat it as though achieving a third representation of women would be the pinnacle of the two-thirds, whereas that is not the point, that's not the case at all. The one-third is ground zero. Our aspirations are towards 50-50. That's actually what is envisioned by this principle. So if 10 years post-promulgation, we still haven't even gotten to ground zero for women, who are half of the population of this country, I think that says a lot about the attitude of the current political leadership. And without singling out a particular one, I want to say that it is all of them, because there is no political party that has a mechanism to implement the two-thirds gender rule. And we have not seen the kind of strong arming or whipping of members to support bills in the House when it comes to the two-thirds gender rule. In fact, they are de-whipped. So for me, I want to concur with Honorable Martha Karua and Council Joyce Majiwa. The time has really come to disband, just dissolve Parliament, because Kenyans must show the political class, must demonstrate to the political class that we are serious about this Constitution. We cannot be talking about amendments to the Constitution when you can't obey the one that you have. And so, for me, I congratulate and thank the LSK for raising the bar on the rule of law using the two-thirds, which was the one bar that was used to lower the bar on the rule of law by the current political elite. So I think the journey is still on, but I'm hopeful that now with the LSK on board, we're going to see some dramatic action. I'll stop there. Thank you.
Thank you very much, Daisy. It's always a pleasure.
So I want to get the benefit of asking Honorable Martha Karua another question before we're mindful that you have to leave early. I hear Professor Kameri Mbote talked about culture and that it's not necessarily a bad thing. And Joyce Majia raises also the question of attitude, that the attitudes have not changed. And Daisy Mdani also talks about that even 1/3 is just ground zero. We are aiming for 50-50. So for you, Audas, do you think that this executive has the goodwill to implement the 2/3? And even with the reforms that are being talked about today, do you think that women stand a chance to benefit from these reforms? Or the critics that are talking about possibly of even losing all the gains that women have even garnered so far? So what is your take on that?
There's absolutely zero political will of the current executive. They cherry pick what parts of the constitution to implement and what parts not to. If you look at how they treat the bills they are interested in, they are able to whip Parliament completely and to make it face the direction they want. So if they really intended to implement the 2/3 gender rule, it would have happened. And there are other ways of implementing the 2/3 gender rule. If during a general election, the parties, and especially the major parties, give equal access to the winnable seats to both men and women, then as many men and as many women will be elected. In South Africa, they do not have quotas. What they have is the deliberate policy of the ANC, where they nominate using the zebra list, because their electoral system is different from ours. It's a party list. And they alternate men and women. It has brought them almost to near parity. One of the ways of demonstrating that Kenya's executive has no political will, look at the way the various bills that have gone through Parliament in an attempt to implement the gender rule have been treated. The whipping by the political class, and especially the major parties, has been lukewarm. I do remember at least some of the parties have even sat in Parliament, the minority parties, the leadership, during the passing. But they too have failed to whip their members to toe the party line, because all our parties talk of gender equality, of not more than 2/3. In different language, all the party constitutions talk about it, and all the party manifestos. No party has ever disciplined its members for failing to adhere to the party policy. And that is a demonstration of lack of political will. I was looking at how the counties have implemented. And to my shock, a whooping 39 counties are unconstitutional in their composition. And whose failure is it? Obviously, that one goes to the IEBC, because it's the one that looks at the math and gives slots for nomination to parties to ensure the gender top-up. If only 8 counties are compliant, it is not IEBC cannot do simple math. It's deliberate. They do not care. It's not just the executive. Our institutions themselves, creatures of the Constitution, are not upholding and defending the Constitution. We have a gender commission, and it is represented here by Sylvester. If the National Gender and Equality Commission cannot do the simple math and tell the executive, inform Parliament and all institutions that we are failing, then something is not working. So this is a wake-up call to institutions, to individuals, to all of us. We need a unity of purpose to push for implementation of the Constitution. And they may think this is a women thing because currently women are the excluded gender, and therefore leave it to women. But the moment you allow impunity in terms of refusal to implement the gender rule, you are actually laying the bed for further impunity regarding other sections. One example is the fight that is going on in Senate about the revenue, division of revenue. If Article 204 on the Equalization Fund had been properly implemented, that is making good allocation and making it work for infrastructure projects in the marginalized counties, by now we would not be talking about marginalization. And if there would still be things unfinished, 8 years on since this government came to power, we would be talking of the unfinished projects. And we would not be talking of literally two countries where some people are faring so badly in infrastructure while others are doing better. If you look at obedience of court orders, which is another impunity, informed, in my view, by the fact that the executive and parliament can get away with it by not implementing the gender rule. Look at how court orders are treated. The worst case scenario being the Miguna order that he be facilitated to return. Court orders are trashed. No wonder then the executive is trashing the court order by the High Court, giving Parliament 60 days within which to get a legal framework, to enact a legal framework to implement the gender rule. It fell on deaf ears. The Chief Justice has been petitioned severally. The LSK petition is the third, if not fourth petition. The Chief Justice has not done his constitutional duty. And I'm hoping that this time he is going to do his constitutional duty. He has no powers under the Constitution to enter negotiations either with Parliament to give them extension. The High Court already gave them an extension, which they never obeyed. His duty now is to advise the President to dissolve Parliament. And once the President gets that advice, the Constitution is very deliberate in its language. It's mandatory. He should dissolve Parliament, which would be a shocker to an institution that is acting with impunity, and it will be a shocker to any other institution and individuals in Kenya acting with impunity, to know that this Constitution applies equally to all.
Thank you very much. I would like to also recognize online joining us is Joseph Sekeyewa, the SRD Regional Coordinator, Monitoring and Evaluation based in Uganda. Madam Helen Oriaro, the Senior Development Officer, Pan-Africa Program, Global Affairs, Canada. Maybe if Helen Oriaro is on, Helen, maybe you could share with us some of your insights in terms of what can Kenya borrow with regards to reforms and the Constitution, and also the 2/3 gender rule based on your experience in Africa and also in Canada.
Maybe we can take the connection.
A bit of an audio issue. Maybe in the meantime, we can move on to the next panelist. Mr. Mbidi, we've heard the calls of our senior Honorable Karua. We've heard the criticism. How many court orders? How many petitions? Please can you share your views, the views of the Commission on the journey and the way forward, please?
Thank you. I'll repeat, my name is Sylvester Mbidi. I work for the National Gender and Equality Commission. First, I will comment on the issue raised by Martha Karua Honorable on the fact that 39 counties do not comply with the 2/3 gender principle. And I think the problem has been in this term of Parliament, the courts, when we went to the courts on the challenge of the issue of nominations for the counties, the courts refused to allow the Commission to file an omnibus petition challenging the constitutionality of the counties and also nomination of persons with disabilities. So the problem has been, whereas in 2013, when we filed petition 117 of 2013, there was an order that IEBC repeats the process, and in the process, we had a situation where all the counties complied with the 2/3 gender principle. In our case this time around, when we filed the case and challenged the manner in which IEBC nominated the county, women and persons with disabilities and the youth in the counties, the petition was dismissed and currently on appeal. And I think we are on the 3rd year since 2017. I do not see there being success. So what am I saying? I think my point is that the courts also have been, the courts have not been consistent. If you look at the petition that is challenging Parliament, it has been there since 2017, immediately after the elections. The petition was filed. That petition has never been finalized. There has been a lot of back and forth. There is one by FIDA, petition 401 of 2017, and 397, filed by Crew and Crown Trust, and where, as a commission, we participate. So basically what I'm going to say as a young advocate who joined this journey after the 2010 Constitution is that I came in when the law was very clear, in my view. I came in after the passing of the 2010 Constitution and the provisions therein regarding gender equality. At the Supreme Court, when the request for an advisory opinion was made, I was there. I was new at the Commission, and the Commission took the position that the implementation of the 2/3 gender principle was supposed to be immediate. However, we were disappointed by the majority decision of the Supreme Court, and we were in agreement with what the then Chief Justice Willie Mutunga had said. So what happened is that the Supreme Court postponed the problem. And also the other problem with the Supreme Court is that it introduced the word progressive realization of these rights, and that has been a problem from the time that decision was made up to date, because immediately after that decision, as a commission, we have approached the Attorney General, then Professor Githu Muigai, and we were saying that we need to come up with a team to at least deliberate on the formula that is supposed to be adopted. And it took a while because the Attorney General constituted the technical working group in 2014 February, and the decision was made in 2012. So there was a lot of time wasted for us lobbying the AG even to constitute a team. And after that, when the team was constituted, initially we were given 3 months to come up with a formula. We had so many proposals on the table, but the one that was the most preferred was one that was lifting the provisions of Article 177. Article 177 is about the county assemblies. There is a provision that in the Constitution we do not say, in the county assemblies we do not say, for instance, all county assemblies should have a certain number of members. In the National Assembly, and I think the drafts before we had the final document, the drafts did not have a specific number of members of Parliament. The original constitution, the other constitution had 210, if I remember. So the problem that was there, in my view, is that when there were negotiations, and Honorable Mother Karua is here, I think in Naivasha, that is when the constitution, in my view, was mutilated. And that is when we inserted provisions in the Article 97 and 98 that were incapable of implementing the provision on the gender principle. However, there were proposals that would allow us to achieve 2/3 gender principle through legislation, meaning that it was not a must that we amend the constitution, which is something that the Attorney General was against. And those proposals, in as much as they were good, they were very much unpopular. And I would give an example. One of the proposals was that we should have a party ticket, where every constituency would file a man and a woman. That's a ticket. And using a certain formula, after the elections and after we realized that we do not meet the 2/3 gender principle in Parliament, then the number 2 in that ticket would take, and that ticket was supposed to have a man and a woman. Another proposal was to have a runners-up, so that we go to the election, and should we not meet the 2/3 gender principle in National Assembly or Senate, the number 2 is a woman, the most popular woman in that election, in that particular constituency, would take the seat. Another one was to rotate the constituencies, to randomly pick some constituencies. Initially, even before before 2012, and before the technical working group, there were proposals that had been made by the IEBC, then called the IIC, the interim election body, that we select the new constituencies that had been created, that were 80 in number, be reserved for women. So my point is that there are proposals that were there and that we considered as a technical working group that were going to implement the 2/3 gender principle without amending the constitution. But the problem with those proposals was that they were not very popular. So the fallback was to adopt the provisions of Article 177(1)(b) and ask Parliament, because in our view that amendment to the Constitution did not require a referendum, we use a parliamentary initiative and amend the Constitution to insert those provisions in Article 97 and 98. In my view, I might be wrong. I think the original draft before it went to Naivasha, it had those provisions. So Parliament mutilated that provision, mutilated those 2 articles of the Constitution, and failed to consider that there was going to be a problem in interpreting, in meeting the 2/3 gender principle. Now, going back to the Supreme Court, I think, as I said, is that Supreme Court postponed the problem to 2015, because if you read the Constitution, the 5th schedule, they were supposed to pass that law by 27th August 2015. However, that didn't happen. On 30th April, which was about 3 months to the deadline, Honorable Samuel Chepkonga then, who was the chair of the JLAC, the Justice and Legal Affairs Committee, published a bill that was very retrogressive. And if you remember the bill, it only inserted the phrase progressive realization in the Constitution, Article 81B. So there was a lot of uproar from the sector, and a lot of lobbying of the political class. And I think by July, that was very few days before the deadline of 2015 August, 29th July, Aden Duale, then leader of majority, agreed to publish the technical working group bill. That is the Duale bill, popularly known as Duale bill. And then the following day, on 30th July 2015, National Assembly was able to garner the numbers to postpone by 1 year. If you read Article 261, and I think it is 261(2), Parliament can extend the 5-year period. So Parliament was able to get the numbers for purposes of extension, but Parliament was not able to pass that bill later, the following year. in April and May. So in April 29th and 5th of May 2016 now, after publishing of the bill, Parliament did not garner the numbers, and we required about 233 members of Parliament to support the bill. And on 5th again, when the Speaker, then Justice Muturi, extended the voting to another day, there was no quorum in Parliament. Initially on 29th, there was quorum. So it ended up with a situation where there was no law that had been passed by Parliament by the deadline. And that's why the petition 371 of 2016 was filed. And that is the resultant ruling of Justice Mativo that then gave Parliament another 60 days to try and do that. My conclusion is that I do not think even the Chief Justice requires to be moved, because my reading of Article 261, I think 7 or 8, there is no requirement of petitioning the Chief Justice. In my view, the petitions that are before the Chief Justice are just escalating the problem. The orders of Mativo were very clear, and that is the only way, the only time the court is allowed to direct Parliament to do something and then report to the Chief Justice. There has been no reporting of Parliament to the Chief Justice on the progress they have made. 60 days lapsed, and Parliament went to the Court of Appeal. The Court of Appeal threw away their appeal. So I do not think the Chief Justice is doing justice by not advising the President to dissolve Parliament. Thank you.
Okay, that's a different perspective. Thank you.
Before I get to you, Jeptum, I'm sure people are quite excited to hear who is We Are 52% Collective. But let me allow Honorable Martha Karua to share a parting shot before she leaves.
Okay, thank you very much. I just wanted to say that our approach ought to be, this is not a time to reopen negotiations. It's not a time to say what could have been at Naivasha, what could have been discussed. We are talking about a constitution that is promulgated, that is in place. It's time for implementation, and when Parliament and the executive, because the executive also has the ability to table bills in Parliament, act with impunity, then under the provisions of Article 261, there is no other option but for the Chief Justice to dissolve Parliament. We shall then, as a people, sit together, faced with that constitutional crisis, and decide how to move, how to ensure that the next election of parliamentarians fulfills the rule to avoid a similar fate of the Parliament that comes. So our discussion today, let us narrow it to what needs to be done, and it's only one thing: dissolving Parliament. Thank you very much.
Thank you very much.
And with that, I beg leave.
Thank you, Honorable Martha Karua. Jeptum, maybe you'd share with us, who are We Are 52% Collective, and what has been your journey to actualization of constitutional reforms to date?
Thank you, Faye. Let me extend my gratitude to the Law Society of Kenya for holding this conference today, to my distinguished panelists today who have spoken at length at the topic, and more importantly to the viewers who have taken time out today to listen to the dialogue that's happening today. Let me begin by saying that members of the We Are 52 Collective were the first people to petition the Chief Justice to advise the President to dissolve Parliament. And our petition was on the 27th of September 2017. This is 2 years before the 2019 petition that our Vice President has said. And in regards to the origin stories of We Are 52%, it started in 2010 when the Constitution provided for affirmative action measures
that allowed for more women representation. And throughout today, you will hear vivid timelines from other speakers to paint for you the picture, starting from 2010 from the Constitution, to 2012, the Supreme Court advisory opinion, to even our 2013 general election that brought the 11th Parliament, to this 2015 also, but that was a Supreme Court deadline. And more importantly, even between then, we can also acknowledge that Parliament had attempted to bring bills to address the gender role, but those fell flat on the floor. So what really spurred us, and what We Are 52 are, is a collective of Kenyan feminists who are frustrated and who are angry, and that their constitutional right wasn't being heard. We weren't being given these voices or the platform to bring this change to Kenya. So in the beginning, it was organically a grassroots movement that came together of women who realized that our greatest power was ourselves. And it was in that active citizenry that we petitioned the Chief Justice. And I'll speak more at length of other projects we've done, but most importantly, we started a constitutional drive and petition from 2017. And more importantly, the reason why we are hashtag We Are 52% is because we wanted to continue the conversation. We wanted to, already because of advocacy groups who went to court, also during the time of Justice Mativo's petition, and we wanted to just continue sparring and bringing more information out there, because the reason why we called ourselves We Are 52% was in 2009, the census. Out of a population of 38.6 million, women accounted for 52% of the population. So that's exactly where our beginning came from. We are 52%. But that representation wasn't anywhere. It wasn't in our judiciary or in our Supreme Court bench. It wasn't in our in even board positions, in constitutional bodies. So where were the women at the time? And I can tell you for a fact that anger and emotion are a very strong, thrusting voice. And it's because of that we continued to talk. We had, more importantly, our digital campaign. And that brought light to us. And that's the reason why we are here, because there's a danger in erasing women's voices.
So, thank you.
Thank you very much. I'd now like to call on Ms. Mercy Janimo, if she can please share some of the initiatives that the Center for the Rights, Education and Awareness crew have taken to further the implementation of the rule, please.
Thank you very much, Valentine. First of all, let me join the rest of the panelists in thanking the LSK for organizing this conference. I think the LSK has been our ally, but never before have they been this publicly active on the matter of two-thirds. So to President Harvey, to the CEO, Madam Mercy, to the council members, to members, also members of the LSK, and I guess the Secretariat, we appreciate. I think on behalf of the women's movement in this country, we appreciate and we look forward to really safeguarding the rights of women in this country. So thank you very much, LSK. For those of us who might not be familiar with the Center for Rights, Education and Awareness, we are a non-governmental organization working on women's rights, and as our name suggests, we mainly focus on creating awareness on all rights, be they political rights, social rights, economic rights of women, and we do not discriminate on the women that we work with. We work with all women in all their diversity. We work with young women, we work with rural women, we work with the so-called grassroots women. We also work with the elite women. We work with women living with disability. We work with women from marginalized communities. For us, it is that women are women and women's rights are human rights. They must be respected. We also try to, I think as an organization, we try of women to really claim these rights, to enable them know that they have rights and their rights are guaranteed in their constitution. So really focusing on civic education. In regards to the discussion of today,
about securing political inclusion of women and on the implementation of the two-thirds. The Center for Rights, Education and Awareness has been on the forefront. We've spearheaded a number of initiatives. We've carried both judicial and non-judicial initiatives. I think the panelists before me have highlighted the judicial initiatives that we've undertaken, and the Center for Rights, Education and Awareness has been a party in all these cases. Just in the run-up to the deadline that the Supreme Court had set of 27th of August 2015, we filed a matter in court just challenging the failure by the AG, the CIC and the Parliament then for the failure to enact a mechanism or prepare a bill that would have enabled the implementation of two-thirds. So I will not dwell very much on the judicial initiatives that the Center for Rights, Education and Awareness have undertaken, but also try to highlight some of those non-judicial, or so to speak, the advocacy initiatives that we've undertaken, because the narrative out there has been that the women's movement in this country has focused only on judicial processes. That's not the truth. We've tried to also do other initiatives. I think for us, we really understand the barriers and the challenges to women's political inclusion, and we try to address this. So allow me to just highlight some of the things that we do beyond the judicial initiatives that we try. I think even the Constitution rightly acknowledges that we need to take legislative measures or steps and other measures in securing the political inclusion of women. So for us, together with all the women's rights organizations represented here, including Contrast, FIDA Kenya, we are 52%, Women's Empowerment Link, the Kenya Human Rights Commission, Kituo cha Sheria, we've really tried to do other things behind the scene. So allow me to highlight some of this. We've tried to, as I said earlier on, to create civic education amongst Kenyans on the needs and the rights of women, on why we need to protect these rights, why these rights are guaranteed in the Constitution, and why all of us also are entitled to these rights. So we've conducted numerous civic education. We've also engaged the media to just try and change the narrative and around women's rights issues and around the conversation on two-thirds. Initially, the conversation on two-thirds has never been as a matter of rights for women, and Senior Counsel Majiwa also highlighted on taking this approach, on adopting a rights-based approach to these issues of women. So we've tried to also change that narrative and using the media really to drive the change the change in the narrative. Further, also we were also seeing that the narrative around the two-thirds was highly skewed towards the increase in the wage bill. And I think the Center for Contrast, and Daisy is here, and she will highlight some of these things, together with the Institute of Economic Affairs, tried to do an analysis of exactly how much will it cost us as a country to implement the two-thirds. And truly we demystified the narrative that was going on around the issues of increasing an already ballooning wage bill. Further, I think we've also tried to conduct extensive engagements with the male parliamentarians. For us, we understand that they are the majority in parliament, and in each single voting day we tried to mobilize. We did a number of things to mobilize just the male parliamentarians to be in parliament to vote when the bills on two-thirds were being tabled. This we worked together with the women parliamentarians, where we asked women parliamentarians to go directly and lobby the male parliamentarians to participate or to appear during the vote day on the matter of two-thirds. What we were seeing before was that on the day of the voting for the two-thirds, the male parliamentarian will always be there will always be a quorum hitch. So we devised strategies of just how to ensure that we have the quorum in the House.
Many a times we didn't meet the quorum, but many a times we had at least we had numbers, sufficient numbers to even debate the matter and vote on the matter. So these are some of the initiatives that we've done. I think also just trying to, let me just reiterate that women are not an homogeneous group so that they easily agree on things. There've also been divisions amongst us, especially on what formula to pursue on the implementation of the 2/3. So we've tried to mobilize ourselves as the women and the women's movement in this country to just have some agreement, and hence that's why you will see that we adopted strategies that would help us in actualizing the 2/3. So amongst us, we created movements. One was the Thuluthi Mbili movement that was largely in support of the lifting of Article 177 of the Constitution, the popularly known referred to as the Duale Bill, where you just lift the articles under 177 and you import them to under Article 97 and 98. And amongst us also there were people that were vehemently opposed to that mechanism. They thought that mechanism was not really empowering and women, and was giving and taking on the same, and also from their learnings from what is happening in the counties. Let me just put it clear, for me, I am a supporter of the 2/3 of the Thuluthi Mbili, of the Duale Bill, but others are not. So for the others that were not against this, they thought that we needed a more aggressive formula, and we formed, and they formed rather, what they call the Green Amendment Movement, and Daisy, I think she's here with us. She will highlight exactly what that formula wanted. So all these initiatives have been taken to really understanding that the issue of the 2/3 is really a matter that is deeply embedded in our cultural and our social norms, and therefore we will need robust mechanisms and robust actions to be able to achieve this. So to conclude, just to make my final conclusion, is that let me just refer to my notes. I just want to say that the search for political inclusion in the context of a deeply patriarchal society requires both short-term and long-term strategies. Therefore, let us be clear, members, that the Constitution and legal framework is a short strategy required to safeguard women's rights, and this Parliament's time to provide the mechanism has lapsed. They've been given, it's been 10 years since the promulgation of the Constitution, and they have failed the women of Kenya. So the women of Kenya are saying that let us adhere to the law and dissolve Parliament. I think the Article 261(7) is very clear that if there is a failure to implement this, then the Parliament has to be, the Chief Justice has to advise the President to dissolve the Parliament, and maybe it is our hope that this action then will make the next Parliament treat this matter with the seriousness that it deserves. So as Honorable Martha Karua has said, there is no further debate on this. I think we've given adequate time on this matter. It is time, and also the CJ, I think it's very clear that his role is to advise the President to dissolve this Parliament. So as women of this country, we are watching, and we are looking at the CJ to really act on this matter. So thank you very much.
Thank you very much, Mercy.
So as much as we'd like to continue with this debate, we have to come to an end. So as we end, maybe in 2 or 3 sentences, I would ask this question to all the panelists. Yeah. So what's your verdict to Parliament or the Chief Justice? And is the Constitution ripe for reform? I will start with Joyce Majira.
Thank you very much. My verdict is the constitutional verdict. The Constitution is very clear what the Chief Justice should do. I'm not going to differ from the Constitution. I want the Chief Justice to follow the Constitution. I'm here about following the Constitution. I'm here about the rule of law. So I want the Chief Justice to follow the rule of law. Is the Constitution ripe for reform? We have just reformed. We are talking about 10 years. If we were a child, a human child, we would not be in secondary school. We would not be pubescent. Let us grow, and if there will be reform in the future, maybe, let us grow, and if there will be need for reform in the future, there could be. There are places like, I think Sylvester has highlighted very well the conflict of what was taken out and was not taken out, which then caused the Constitution to have alignment issues. Maybe, just maybe, and I'm actually one of the first few people during the time when Mutula Kilonzo, when he was alive, may God rest his soul in peace, brought the first constitutional amendment to say that let us do a top-up, lift 177 and bring it to a National Assembly and the Senate. I'm one of the people who said, yes, let's do that. People, again, as Mercy said, do oppose you. They said women should not be the ones to help break the Constitution. And should never ever have constitutional amendment. So in my view, reform, I wouldn't call it reform. I wouldn't call it anything reform. Let us implement fast. We don't know what are we reforming if we have not already finished implementing. In my view, let us implement the Constitution as it is. Let us find mechanism, and it is not difficult to find a mechanism. Even now, there is a law which is in the I hope it is still on the floor in terms of Article 100, which will also help ease this two-third gender principle. Let me just say this. Even here in the Law Society, we had actually brought a motion for affirmative action, which was over during Nzamba Kitonga, which was overwhelmingly booed, and look at us now. So I tend to agree with Professor Patricia Mbote that this gender rule is for everybody. Let it stay there in the Constitution. It will help the men and it will help the women. Thank you.
Thank you. I think in my concluding remarks, I was very clear that we've given Parliament adequate time to do what is necessary, and they've failed us. So in terms of what the next step, we are very clear that the Constitution is also very clear, and as a country that adheres to the rule of law, it is time to dissolve Parliament. It's time to implement Article 261(7) of our Constitution. In regards to whether we are ripe for the reforms, you know, we cannot reform something that we've not implemented, and I think the two-thirds rule really serves as a good basis on why, if we've not even done such a small thing as inclusion and representation of the people of this country, why then would we, focus on reforming this Constitution? So perhaps I think we need to implement the Constitution first, and just not cherry picking. I think Martha Karua referred to cherry picking on the articles of the Constitution that we implement, but rather treat that thing, treat and implement the Constitution holistically. So I think I joined Senior Counsel Majiwa in just saying that let us implement the Constitution, and let us implement Constitution with the view of promoting and making this country of ours a better country, developing it, making it an equal society, making it a just society before we even talk about reforms to the Constitution. Thank you.
Vice President Caroline Kamende.
Thank you. From where I sit, Article 10 of the Constitution obligates all of us to respect, uphold, and defend the Constitution. From the provisions of the Constitution, it is clear that there is no room for amendment, in the sense that those provisions are clear and can be implemented if only there was political goodwill. The Court of Appeal, in its ruling in the Crew case, observed that there was no political will and good faith on the part of Parliament to implement the two-thirds gender rule under Article 27 and 81B of the Constitution. So to me,
we should guard against retrogression. We should not make the laws any weaker. We should demand for implementation. As the other panelists have also observed, we cannot start changing and reforming what has not started being implemented or enforced. So for me, I would say that we should take the last resort that is provided for under Article 2617. There was the brains behind that provision of Article 2617 on the dissolution of Parliament may have been looking at the this traditional marginalization of women. Today, as Honorable Mother Kanrua says, we are looking at women. Probably 10 years from now, it will be the men seeking for implementation of this 2/3 gender rule. So the provisions as per the Constitution are implementable. Let the CJ do his part as mandated by Article 2617. There is no discretion to it. Let the President of the Republic of Kenya also perform his obligation under that provision. He has no discretionary powers to negotiate or return the petition or the advice by the CJ to the House. So for me, it is not time for us to speak about reform of the Constitution when we have not started the journey on implementation. So our position as a law society, and my own position would be dissolve Parliament. It has failed us. Thank you.
Sylvester Mbithi.
Thank you very much. I think many have said that this matter of the 2/3 gender principle is not about women. And what Professor Kameri Bote said, that in her lifetime she was hopeful that you will see men fighting for this principle when they are down there and it is women that are up there. And I can rightly say, at least within the Law Society of Kenya, I'm one of those people who may push for amendment of the Law Society of Kenya to provide for affirmative action for the men. Because if we go to the elections and we use the first past the post system, where the one that garners the most votes will be elected, then there is a likelihood in the future, particularly when we address the issue of political parties and the party primaries that usually happen. If we find women in our candidates in those the same number as men in those ballot papers, because that is where women because they don't make it to the ballot paper. If there is a way of making sure that women make it to the ballot paper, that would be a done. And most likely it would be a matter of the ballot, and if there is no rigging, then the women will get it. Parliament has said that is very true, and many have said that. And then it is only Parliament that has the power to make law. So not us, not the President, not the President, parliamentarians, when they sit as Parliament, either National Assembly or the Senate. To be chaired by Senator Wako. We've gone there, presented the proposals. They have given us work. Go back and give us an idea on this. Go and refine this proposal. At the end of the day, they don't pass the proposal that was given to them. So I think Parliament has latitude to reject a particular proposal, but it has no latitude to say, because there is no proposal, then we are not going to do anything. I think because it is their primary responsibility to pass that formula, I think now it is upon them. So many proposals are there documented and shared with Parliament. If they do not take action, in my view, then the Chief Justice has no alternative but to write to the President and advise him kindly dissolve Parliament, because Parliament has failed. And I reiterate what I had said, that in my view, it's not a question of going to the Chief Justice, litigating before him, for him approaching Parliament and telling them, why don't you look at this bill and pass this, or, you know. For me, it is a question of, is the Chief Justice aware that Parliament has failed? And in my view, yes. Why has he not written to the President, so that we can shift our guns to the President? We started with the Supreme Court in 2012. We were disappointed, but we went to Parliament. Parliament has disappointed us. We must go to where the Constitution takes us, and that is the Chief Justice. If the Chief Justice does not disappoint us, he will write to the President. It is the President that we will turn our guns to after that. So my take is that the Chief Justice should do the right thing. He should advise the President, and the President, again, if you read that article, 261(7), the President, it is written there, the President shall dissolve Parliament, and then Parliament shall start all over again. So that is my view. As regarding reform, in my view, we have not implemented the Constitution. Let us first implement. Then we can talk about reform. Thank you very much.
Ms. Jeptumo.
Thank you. Well, I can reiterate what was being said today. I would like one takeaway to be had today, that you are never completely voiceless. And Kenya has such a rich history of citizen activism that we are 52%, like I said, was just a collective of women as young as 18 all the way to 65 who knew what they wanted, who knew that the only resource they had was their time. And we put in time, and like I said, our digital campaigns are now archived, and they have continued to bring the conversation to right now today, that you can't, we're not starting from scratch. You know, people have done the work that when you say dissolve Parliament, we know that the Parliament needs to be dissolved. So while I say this, I would like everybody to know that you will never be voiceless, and there are mechanisms in place. You will find community, you will continue the good work. And now we're knocking on the Chief Justice door. There's no other way that we can go about it. So thank you.
Daisy Amdani.
Ms. Amdani?
I'm on. Can you hear me?
Yes.
Can you hear me? Okay. Yes, so I want to say this. I think it's important that we understand that because there has been no political cost to shortchanging women in Kenya, we are now witnessing a regression in the two-thirds gender principle. Already, as has been stated, we have 39 counties where, in the face of an actual mechanism, Article 177B, still are not compliant. I mean, you're talking about 39 counties, 39 or 37 counties, okay? That is over half of the country. We have a cabinet that is not compliant. The current cabinet, as presently constituted, does not meet the two-thirds gender rule, notwithstanding the judgment that was rendered by the late Honorable Justice Onguto, that the cabinet post the 2017 election must comply with the two-thirds gender principle. The parastatal appointments do not comply with the two-thirds gender rule, neither does the appointments to the diplomatic corps or even to the civil service. So in essence, we are regressing, okay? And we are regressing because the political class has seen there's no cost to them. Not implementing the two-thirds gender principle has not been costly to them politically. So the lack of a cost of shortchanging women has enabled them to totally disregard the Constitution and to disenfranchise over half of the population. And I think it's important we understand that. Parliament has played a very critical role in supporting the executive to shortchange women and to negate the two-thirds gender principle, because we must remember that cabinet is vetted by parliament, as are diplomatic corps nominees. At a basic, the one requirement is, aside from them, the nominees meeting the qualifications for those positions, the list itself must meet that threshold. And we actually wrote to Parliament and individual vetting committee members to inform them of the late Justice Onguto's ruling, and they disregarded it. So moving forward, I think that it is important that the Chief Justice also stops coloring outside the lines, as it were, because it is true, the Constitution does not give him the discretion, once a petition has been lodged, for him to confer with Parliament as to, so how far have you gotten? Because this Parliament, the 11th and the 12th Parliament, have sat now for 7 years and they have not done anything. So you cannot tell us that in the next 1 year or a few months that they're going to do something different. I think the time has come for the rule of law to be upheld in this country. We cannot continue to pay lip service to adherence to the rule of law when in practice we show that the rule of law does not matter. That fosters a culture of impunity and anarchy. And it is worse when it is led by the leadership at the highest level. Cabinet should also be dissolved, not just parliament. This entire government should be dissolved. Why? Because as the first government elected under the new constitution, it was given the sacred responsibility of midwifing and animating a very progressive constitution that is celebrated the world over for how progressive it is in terms of inclusion and fostering that inclusion. But by refusing to implement the inclusivity principles, then they have themselves disqualified. They have disqualified themselves from even being in government. The presidency, the legislature, and the legislators derive their powers from the Constitution. If they cannot obey it to ensure that it meets the basic principles of inclusivity, then they also disqualify themselves from the right of exercising the powers in that Constitution. So let Parliament be dissolved and let it go down in history that at least the judiciary supported the people of Kenya in upholding the principles that they enshrined when we gave this Constitution to ourselves. With regards to amending the Constitution, if you cannot abide by the Constitution right now, what is going to cause them to abide by it later? There is a culture of impunity in Kenya. There is nothing that is being proposed in those amendments that are not well captured in the current Constitution. And they must first tell us what is stopping them from implementing them, you know, those 9 points that they have so aptly captured in the building bridges. What is stopping them from implementing them now without having to amend the Constitution? And I caution Kenyans, there are only about 10 issues that need to go to referendum. And one of them is the Bill of Rights. And that is where the two-thirds gender principle is docketed. That's why it's been so hard for them to remove it. And so when we talk about amending the Constitution using a referendum, because the Constitution can be implemented without a referendum. You can do it through parliamentary initiative, you can do it through popular initiative. But the referendum issues are issues that we have seen a refusal to implement. The Bill of Rights is one of them, the two-thirds, the independence of the judiciary, the sovereignty of the people, the independence of the commission, the independent commissions. So if we are giving them the keys to take back the powers that we gave to ourselves, then we will have nobody to blame but ourselves. I say, tekeleza katiba. That should be our call. Thank you.
Very much.
So we'd like to end it with the wise words from Daisy Mundani, tekeleza katiba. You've heard it straight from our panelists. The verdict is out, and this is not a fight for the lawyers of Kenya, nor the women of Kenya, but it's a fight for the people of Kenya. Supremacy lies in the Constitution, in the people of Kenya, and therefore the 2/3 gender rule is for the people of Kenya. And we are asking our viewers and our members, be wise and be proactive and protect the Constitution. Thank you.
Thank you very much. Thank you.
Thank you.
Thank you, Faye. And Valentine, for taking us through the second panel of this conference. Indeed, the discussions have been very insightful, informative. We can now all understand the journey that we have taken towards ensuring that the 2/3 gender rule has been implemented, and up to where we are, where we have been forced to now petition the Chief Justice, together with the other petitioners, to advise the President to dissolve the Parliament. I would like to pass sincere appreciation to Honorable Mother Karua, who has already left, for joining us during this second panel. Senior Counsel Joyce Majiwa, thank you very much on behalf of FIDA. Our own Vice President, Madam Caroline Kamende, thank you very much for being part of this panel and making it clear to the public why we feel that it's time for the Chief Justice to do what the Constitution requires him to do. On behalf of the National Gender Equality Commission, thank you, Sylvester Mbidi, for being the man in this panel and making it clear to us the work that the National Gender Equality Commission has done. Jeptum Bulut, thank you for reminding us that women are 52% population of this country, and yet we are there. We appreciate #WeAre52% for being part of this panel. On behalf of crew, Mercy Jelimo, thank you very much for participating in this forum. Once again, our partners who have joined us through Zoom, Global Affairs Canada, SRD, we thank you all for being part of this panel. We will take a break, after which we will come to the third panel. We will discuss steps taken by Parliament to enact legislation. The members of Parliament themselves will be here, and they'll be telling us what is it that they have done, what is it that they have not done. Why are Kenyan women and Kenyans generally crying to the Chief Justice to dissolve Parliament, while they have had all the time, 10 years down the line, to do what the Constitution requires them to do? Members who have joined us online, members of public, we also want to thank you for tuning in. We take a break. We'll be back immediately at 2 p.m. Thank you.
The judge